Brandon Boudreaux. Chad Daybell, not implicated in regards to Brandon Boudreaux. You know what Chad did? You know why he's not implicated? He carried a tire from a storage unit from a Jeep. And the prosecutor down there recognized you don't have an agreement there because you carried a tire. You don't have an agreement because Chad Daybell has religious beliefs that we don't believe in. What they have is they have Alex Cox shooting at Brandon Boudreaux and Lori Vallow down there involved. And that's what you have down there. Do not speculate as to any other case or legal proceeding involving the alleged co-conspirator. It's in black and white. Facts, evidence. Again, that fancy French word, voir dire. I talked to you folks about that. I talked about facts and evidence. Fact. Chad Daybell was not involved with Charles Vallow. Fact. Chad Daybell is not implicated with Brandon Boudreaux. Fact. Chad Daybell espoused religious beliefs. And if you want to believe the prosecutor, well, maybe Chad Daybell did a south-southwest search. Where's the agreement? Where is the agreement? It's not there. You must remember, the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his innocence based solely on the evidence provided in this case. It's the judge's instruction. It's not their instruction. It's not the four of them over there. It's the guy that matters here, who sets the instruction and tells us the rules we have to follow. And the rule is, you must remember the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his innocence based solely on the evidence, the facts and evidence that you have been presented. That's what you have to consider. We don't speculate. We do not guess. We do not engage in conjecture. We don't do any of those things. Facts and evidence. Facts and evidence. Reasonable doubt. Under our law and system, this is jury instruction number 5. Again, this isn't me speculating or saying anything, maybe making guesses, maybe giving you facts that maybe aren't consistent with what you remember in your notes. You all took notes. You all have a memory. I know it's been a couple of months, but you all took notes and you all have a memory. And the judge's other instruction would be, rely on your memory. Rely on your notes about what you remembered, not what the lawyers say. That includes me. If I say something that's different than what you remember in your notes, you rely on your notes. They said something different than what you remember, you rely on your notes. You rely on your memory. That's the way this works. That's why we all have memories. That's why we all take notes. That's why we all document what has been said for the last 2 months. I watched all of you take very careful notes. I watched all of you document what was being said. Rely on your notes. Rely on your memories. Under our law and system of justice, the defendant is presumed to be innocent. The presumption of innocence means 2 things. The state has the burden proving the defendant guilty. The state has the burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Chad doesn't have to do anything. He could sit back there and just let the state do their thing. And if he did that and they never proved that there was an agreement, you can't say they put on more evidence than the defense did. That's not the way this works. They have the burden to prove that there was an agreement. They have a burden of proving that Chad in some way was involved in the murder. Now, the insurance cases go back to, well, if Chad was planning a murder, that way he lied and he took advantage of the insurance. And that's how that works. Because if you folks find that he wasn't involved in the conspiracy or the murder of anybody, there's no insurance fraud case. Doesn't have to provide any evidence at all. Now, you know 4 experts. Dr. Bartling, and we're going to get to that in a little bit. Dr. Hampinkian, Dr. Raven, Patrick Eller. He didn't have to do that. Chad didn't. It's not his job to prove innocence. It's their job, and it's their burden to prove guilt. They have the obligation to prove guilt. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not mere possible or imaginary doubt. It is based on reason and common sense. So when you think about reasonable doubt, what you're doing is you're saying, okay, do I have a reason to believe or doubt whether Mr. Daybell is guilty, whether Chad did this? Do I have and using my common sense and reason, is it possible Chad's not guilty of this? That's reasonable doubt. If you're saying to yourself, I don't know what happened, I don't know the truth, I have no idea really, maybe we will never know what happened here. If that's going through your head, folks, and you don't know which way this is supposed to go, or you have some doubt in your mind whether the state proved their case, the verdict is not guilty. And under our system of justice, it has to be not guilty. Because you can't just bring a bunch of people in from a school who suddenly espouse that Tammy was perfectly fine, and one after another, and bringing the principal in, and bringing anybody who ever even spoke to Tammy once, or once a week, or anybody else, and saying, oh, she was healthy. And yet they didn't show there was a significant discussion about her health. And we're not supposed to believe her family. We're not supposed to believe her son and her daughter who knew her better than anybody else. And then I guess what the state would like to do is, well, believe all of these 9, 10, 12, 15 teachers and principals and everybody else who was dragged in and said, oh yeah, healthy as a horse. Okay. Common sense. Common sense. That's what you need to do. It may arise from careful and impartial consideration of all the evidence or from the lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. If you have a doubt and you don't know what happened, you must find Chad not guilty. That's not from me. It's not from them. It's from the one that matters, the one who sets the rules and tells you what the instruction is. And read it for yourself. You're going to get a copy of the instruction. It's jury instruction number 5. You must, if you have doubt, Chad doesn't have to prove anything. But if you have doubt about what happened here, the verdict has to be not guilty. That's what the law says. This is jury instruction number 8, and I want to, when you pull up jury instruction number 8 with you folks in the booklets that you get, you'll see that I only took a couple of sentences out of that. In all fairness, jury instruction number 8 is much longer than this, and there's a lot more information in there. But what I did is I pulled out what the theme and what I wanted to talk to you about. And on jury instruction number 8, as part of it, it says, in determining the facts, you may consider only the evidence admitted in this trial. You consider the evidence that has been presented to you. There has not been any evidence saying, we're going to kill the kids, we're going to kill Tammy. There is talk about a plan. Yeah, the 144,000 building a village for the children, the infirm, the sick, the other people that Chad is able to gather. There's the plan, and if you go through the evidence, you'll see there's reference to the plan. It wasn't a plan to kill, folks. It was a plan to gather. A plan to gather by a gentleman who's a traditional Mormon. And yes, you don't have to like his beliefs. You don't have to agree with his beliefs. But he sure has the right to believe whatever he wants to believe. Second line, and again, you'll see the ... is because the jury instruction number 8, I want to say it again so that we're very clear. I didn't publish the entire jury instruction number 8. I took these 2 paragraphs out. And when you read the rest of it, you'll see it basically covers the same subject. There's other topics in there that talk about it. But under the second sentence, do not attempt to guess what my answer might have been or what the exhibit might have shown. That goes back to what I talked to in the very beginning of the trial. You can't speculate. You can't guess. You can't engage in conjecture. You can't say, this is what he must have meant, or this is what she must have meant, or this is what they meant by this. No. You look at the evidence, and unless it tells you something, you take the evidence as you take the evidence. Again, the judge's instructions. This talks about jury instruction number 18, and the state talked about this a little bit, and I'm going to go through the whole thing, and I'll be quick, okay? The law makes no distinction between a person who directly participates in the acts constituting a crime and a person who either before or during the commission intentionally aids, assists, facilitates, promotes, encourages, counsels, solicits, invites, helps, or hires another to commit a crime with the intent to promote or assist in its commission. That was a lot. I can talk, but that was a lot. In other words, what that's saying is that if there was a murder and someone did something to help along, aided in that's a problem, and it is. Okay? But then we go down to the last sentence, and this is what's important, and this is what you need to look at. And in all fairness, I wanted to put the entire jury instruction so you could put it into perspective. Mere presence at, acquiescence in, or silent consent to the planning or commissioning of a crime is not sufficient to make one an accomplice. Okay? What that's saying is this. Chad Daybell can talk about religion all day long. Chad Daybell can espouse his beliefs, and he could talk about zombies with Zaluma, or Melanie Gibb can teach about zombies, and Chad can talk about dark spirits. Chad can talk about light and dark. Chad could talk about all sorts of religious beliefs. Okay? But when the time comes, if something happened to those children, even if Chad had knowledge, acquiesced, or silently said, well, I may know about this, I may know what have happened, what that instruction on number 18 is saying, mere presence at, acquiescence in, or silent consent to the planning or commission of a crime is not sufficient to make one an accomplice. Accomplice means no conspiracy unless he took some sort of a step to make an agreement. There has to be an agreement. We're going back to that again. There has to be an agreement. There is no agreement. Chad Daybell testimony, he met Tylee a couple times, met JJ a couple of times. There was not a lot of contact. There was not a lot of encounter from when they first met to the time they moved to Rexburg. And you heard the testimony. I want you to go back and listen to the testimony, okay? I want you to look back at Jason William and really listen to one of the exhibits that's been admitted, and state provided that a little bit, provided a portion of it anyway. Lori Vallow is talking about a family attorney. Now, for those of us who know what a family attorney is, they deal with divorce, they deal with custody fights, they deal with all of those topics. Chad said, the kids are okay, it'll be cleared up in time. There's a simple solution. He calls Melanie Gibb, talking to her, and if you listen back to the tape recording, basically in essence he's saying, where are the kids, Melanie? What's going on? I thought they were with you. He did say, don't lie to the police. Well, you know why? Because he thought Kate and Larry were in the process of trying to take the kids from Lori. Where did he get that from? Guess where? Lori Vallow. Chad didn't know where the kids were. Chad didn't know where the kids were until that fateful day on June 9th, when they're discovered on his property. Up until that time, Lori Vallow was selling to Jason William and anybody else who would listen the family attorney line. The kids are fine. And you heard Lori Vallow talk about it. If nobody knows about it, the better. She said that. Only I need to know what was going on. I'm the one who needs to know what's going on. And if nobody else knows anything, they can't do anything about it. That was the dupe on Chad Daybell. The kids are fine. It's all going to be cleared up. There's a simple solution. We're hiring a family law attorney to deal with it. They're not hiring a criminal defense attorney. They're not hiring a criminal defense attorney. So Lori Vallow's decision to hire a family law attorney and Chad going along with it because there's a simple solution. Kids are safe. Everything's going to be fine. Mere presence, acquiescence, silent consent doesn't get you there. Even if he knew there was a crime, even if Chad Daybell knew, well, maybe the kids aren't safe. The testimony is everything's fine. Simple solution. But even if you don't believe that, even if you don't accept that and say, how could he not know where the kids were? I want you to look at jury instruction number 18. Mere presence at, acquiescence in, silent consent to. It doesn't get you there, and it doesn't mean he committed a crime. He's saying the kids are safe because Lori told him the kids are safe. He's saying it was a simple solution because this was a custody fight, because Kay and Larry were trying to take the kids, JJ anyway, from Lori. Lori talked about that with Detective with one of the detectives on the 26th of November. He talked to Ron Ball, Officer Ball's here, I think. Front row. Talked about it with Ron Ball. The other thing about that tape that you need to understand, the other thing about the tape, and I didn't mean to go on this long, and I'm sorry, I guess I may not have been completely forthright. It's going to take a little longer than I thought, but I want to emphasize this stuff. I apologize for that. The other thing is when you listen to the tape with Ron Ball and the other officer, okay, you hear Lori Vallow talk about, well, I'm only here for a short while, and this is in September, when they first started looking for where the kids are. And go back to your notes, go back to your memory, but then go back to the tape and listen to the tape where Lori Vallow says, well, I'm also going to be planning to move back with my friend Melanie Gibb. That was in September when she moved here. The kids were here, and she's already planning. She hadn't even been here for very long, couple months, and she's already planning on moving back, and she said it in her own words, with my friend Melanie Gibb. After being 2 months here. Okay, and that's important. Remember that. Jury instruction 18, acquiescence. And it's a big word. Okay? And I looked it up in the dictionary. I'll admit that, okay? I looked it up because I know what silent consent is. But when you look up acquiescence, it says awareness, acceptance, compliance. I'm aware of it. All right, I'm accepting it. I'm going to go along with it. That's acquiescence. I'm going to just go along with what is going on. So even if you think Chad Daybell should have known, but there was no agreement, there was no evidence that he entered into this plan to do this. The prosecutors over at Axe talk about espousing religious beliefs. They don't mention an agreement, but they know You got to have an agreement first before you get to the overt acts. I showed you that earlier. And acquiescence means I'm aware, I accept, I'll even comply. Mere presence, acquiescence in, or silent consent, the planning or commission of a crime, is not sufficient to make one an